Welcome to the deep dive. Today we're grabbing a key from the legal toolkit. You know, the one that decides who pays for an accident. We're diving into actionable negligence and specifically that huge legal gatekeeper, proximate cause. Our mission, to figure out where the law draws that really strict line, between a foreseeable accident and something, well, too remote, too weird maybe to hold someone responsible.
Yeah.
We want the core mechanism that manages liability risk.
And that mechanism, the one you really need to get your head around, is proximate cause. It's easy to confuse just being careless, simple negligence, with actionable negligence.
Right.
To really understand this, you have to see how courts use these elements, especially foreseeability, as a kind of tool. It prevents liability from just spiraling out of control.
Okay.
So we're going to use a key case, Osborne v. Atlantic Ice and Coal Co. from North Carolina, 1935. It's perfect for really breaking down this test, showing exactly how the court decides when the chain of blame gets cut.
Okay, let's unpack that chain. Before we get into Osborne, what's the doctrinal foundation? What's the legal hierarchy required for a plaintiff to actually recover for a personal injury? What links have to hold?
Well, the law sets out a pretty clear standard, like a three-link chain. First, you need actionable negligence. That means there was a duty and the defendant breached that duty.
Duty of breach, got it.
Second, that negligence absolutely has to be linked by proximate cause. Think of it as the legal connection between the careless act and the injury itself.
The effective link.
Exactly. And third, and this is crucial for Osborne, proximate cause demands foreseeable injury. If any one of those links, the negligence itself, the proximate cause connection, or the foreseeability test, if any link breaks, the whole claim fails. Done.
Okay, so foreseeability is the ultimate test here. What's the black letter rule? How does the court define what we're actually supposed to anticipate?
The basic rule is that people are only held liable for consequences they can and should foresee. And importantly, consequences they could guard against using reasonable care and prudence. It's not about predicting everything.
Yeah, crystal balls needed.
Right. It's about reasonable care to prevent harms you ought to anticipate.
That sounds like a significant shield for defendants. It seems to lead right into this idea of a policy limit, something that stops liability from just, taking over everything we do. What's that constraint?
It's this core idea of reasonable foresight versus, well, knowing everything, like Judge Brogdon famously put it, and the Osborne court noted this requiring more than reasonable foresight would practically stretch foresight into omniscience.
Omniscience.
And the key quote is, "The law does not require omniscience." That's a huge policy point. The law demands reasonable action, but it won't make you pay for bizarre, unpredictable chains of events.
Okay, that constraint, no omniscience needed. That's the lens for looking at Osborne. Let's dive into the facts now and see how this plays out, especially when the defendant was clearly negligent in some other way. Let's analyze Osborne v. Atlantic Ice and Coal Co. First, what are the legally dispositive facts?
Okay, facts. We have the defendant's employee driving a company truck loaded with ice. He offers a ride to the plaintiff, who's a 7-year-old boy. The driver starts to slow down, applying the brakes so the boy can get on. But, the brakes are defective.
Defective brakes. Okay, that seems important.
It does, but here's the key part. Before the truck actually stopped, the boy jumps onto the moving truck, he grabs the door, loses his grip, falls, and gets injured. And there were 2 lawsuits, actually one for the boy's injuries and one from his father for loss of services. They were handled together.
And given all that, the driver offering the ride, the bad brakes, the boy jumping, what was the core legal issue the court had to wrestle with?
The precise legal question was this. Was the boy's specific act, jumping onto and falling from the moving truck, a consequence that the defendant's driver could have reasonably foreseen? If so, then you'd have proximate cause. If not, then no proximate cause.
So it wasn't just was the driver careless, but should the driver have anticipated this specific outcome? Interesting. What rule of law did the court apply? Give us the full black letter rule and its elements for this case.
Right. The rule they applied is fundamental. Foreseeable injury is a necessary part of proximate cause. Liability only attaches if the specific injury complained of was reasonably foreseeable while exercising due care. In this case, the court really zoomed in on 2 key elements or maybe aspects of that foreseeability test. First was the driver's act slowing the truck down. The cause, in fact. Like, did it put the boy in the position to be injured? That's sort of implied, setting up the chain.
Okay, cause, in fact.
Second, and this was the main event, was the specific injury the fall that happened because he jumped on a moving truck? Was that something the defendant, using due care, should have reasonably foreseen and guarded against?
Thank you. Now for the court's elemental analysis. Let's walk through this element by element. How did the court apply that second element, the crucial one, about foreseeing and guarding against the specific harm?
Okay, so applying that element. The sub-rule is, again, the driver only needs to guard against reasonably foreseeable results. Now, the driver did invite the boy, and he was slowing down, presumably to stop safely. But the court zeroed in on what the boy did. He jumped onto the truck while it was still moving.
The boy's action.
Exactly. The court decided this was an unexpected intervening act by the child. The harm wasn't something like falling off a parked truck or maybe getting hit if the truck lurched, things you might expect. It was falling off because he jumped onto a moving vehicle. So, the court concluded the driver could not have reasonably foreseen or guarded against that specific impulsive act by the boy.
Wait a second, though. That feels a bit off. The source material really highlights those defective brakes. The truck went 15 feet after the boy fell before stopping. Isn't that clear negligence? Defective brakes seem pretty foreseeable as a danger. How did the court handle the defective brakes issue when thinking about foreseeability? Did the company kind of get a pass on the bad brakes just because the boy acted unexpectedly?
And that's why this case is such a classic teaching tool for proximate cause. Yes, the defective brakes were almost certainly negligence, a breach of the duty to maintain the truck safely. No argument there. But critically, the court decided that negligence didn't change the proximate cause analysis for this specific injury.
How so?
They isolated the injury, the boy jumping and falling from a moving truck. Since that specific event was ruled unforeseeable and intervening act, the necessary element of proximate cause was missing for that harm. So even though the brakes were bad, that particular negligence wasn't the legal cause of this particular injury.
So the logic is, even if the brakes had been perfect, the boy still jumped onto a moving truck and likely still would have fallen. Therefore, the bad brakes were, I guess, irrelevant to this fall.
That's precisely the court's reasoning. The defective brakes didn't proximately cause the fall from jumping onto a moving vehicle. The law demands that the specific breach of duty be the effective legal cause of the harm suffered. Now, if those bad brakes had failed completely, causing the truck to, say, surge forward and hit the boy waiting beside it, well, then the brakes would absolutely be the proximate cause of that injury.
Okay, I see the distinction.
But here, the court found the boy's own action broke that chain of reasonable foreseeability, linking the driver's initial actions, slowing down, having bad brakes, to the specific way the injury occurred.
Right, so after analyzing those elements and concluding the specific injury wasn't foreseeable, what was the court's final conclusion?
The bottom line was clear. The court found an absence of foreseeable injury. Because of that, they upheld the trial court's decision to dismiss both the boy's case and the father's case. Judgments of non-suit were affirmed. The message was pretty strong. Negligence alone isn't enough. You need that link, that proximate cause established through reasonable foreseeability of the actual harm.
That really clarifies the limits. Okay, let's push this boundary a bit with a hypothetical, something visceral to nail down this difference between foreseeability and omniscience. Let's say the driver, knowing the brakes were bad, manages to stop perfectly safely this time. Okay, truck is stopped, but 5 minutes earlier, a chunk of ice fell off the truck, melted a bit, and mixed with a tiny unnoticed oil leak from the truck, creating a slick spot on the sidewalk right near the door. The boy, excited to climb aboard the now safely parked truck, runs over, slips on that hidden ice oil slick, breaks his leg. Now what? Does foreseeability change? Is the company liable now?
That's a great hypothetical because it tests that omniscience line perfectly. The law expects reasonable precautions, right? Maintain your brakes, drive safely, maybe secure your load.
Standard stuff.
Yes, but expecting a driver to anticipate that melting ice will combine with a tiny, maybe unknown oil leak to create a specific hazard in a specific spot that this particular boy will then slip on 5 minutes later. That starts to feel like predicting the unpredictable.
So even though there's negligence there, the oil leak, maybe unsecured ice, the slip and fall injury itself is like too disconnected, too remote.
Exactly. It probably falls outside what's reasonably foreseeable. The law looks for consequences that are, natural and probable. A freak slip on a hidden temporary patch created by a unique combination of factors that's likely too far down the chain of possibilities. It really reinforces that point from Judge Brogdon. The law demands reasonable care, not the ability to foresee every conceivable unusual mishap, not omniscience.
Got it. That makes the framework much clearer. So for everyone listening, maybe prepping for an exam or just trying to understand legal liability, can you boil this down? Synthesize the rules from our deep dive into a step-by-step checklist for spotting and analyzing proximate cause.
Absolutely. Here's a diagnostic checklist you can use when you see a negligence problem, especially if proximate cause looks like the main hurdle. 1. Check for actionable negligence. First step, always. Are there facts showing a duty of care? Did the defendant breach that duty? Pinpoint the breach, like the bad brakes or offering the ride in Osborne.
Okay, duty and breach first.
2. Check for injury. Simple enough. Did the plaintiff actually suffer harm? Physical, financial, whatever is claimed.
Harm confirmed.
3. Analyze proximate cause. This is the critical step. Was the injury a direct, natural, and probable result of that specific breach you identified in step 1? Look out for intervening acts, like the boy jumping. Did something unexpected break the chain?
Test the link.
4. Test foreseeability. Get specific here, ask. Was the exact injury, or at least the general type of injury that occurred, reasonably foreseeable to someone exercising ordinary care at the time of the breach? Don't just ask if any injury was possible. Was this kind of injury foreseeable?
The specific injury test.
5. Conclusion. Put it together. If that specific injury wasn't reasonably foreseeable, even if the defendant was negligent in some way, then the chain of proximate cause is broken. Result: no actionable negligence for that particular harm.
That framework is incredibly helpful. Osborne really drives home that just being careless or negligent about one thing doesn't automatically make you liable for everything that follows. We aren't responsible for the entire universe of outcomes that might somehow connect back to our actions. That legal concept, foreseeability, is the essential shield. So, a final thought for you, our listener. Next time you hear about an accident, try running it through that checklist. Was the first act negligent? Sure. But was the final result something that person should have reasonably seen coming? Or was it just out there, something truly unforeseeable? What everyday risks that seem minor might actually be legally foreseeable, versus those truly remote possibilities the law rightly tells us we don't need omniscience to predict. Something to think about.